second. All right, should hear you now.
You got me?
I can hear you. Let me turn it down just a little tiny bit here. It's a little bit loud. All right, talk for a second.
What about now? You got me now?
Yep. Yeah, that'll work. All right.
Well, he's a busy man to get a hold of these days, huh?
Well, you know, a little bit, I guess. What's going on, brother?
Oh, not a lot, dude. Just been fighting the good fight here in New Mexico, trying to, obviously you're on a much higher level than what I'm running here. I'm pretty much running local for, kind of a small county, so to say.
Well, we're all in the fight together. That's where we're at. All in the fight together. Did you twist that one?
That's what I keep telling everybody is,
a little bit that one.
if we're not going to stand together, it's not going to happen for us.
Right. Absolutely. Yeah.
So, no, I was just wanting to get your opinion on a few things here and kind of get your word out also. That way the people here in New Mexico get an idea of what you're doing as well.
Okay. All right. So just so everybody knows, this we are live on TikTok. This is with my brother Patrick, and he's out in New Mexico. So he had some questions, and we decided to go ahead and bring it live here. If you guys want to watch it live, see both of us, you can go over to TikTok to what is it, Rock Crusher?
Yeah,
575.
575.
Yeah, Rock Crusher 575 in the live. And you can watch it from there, or you guys can listen in here. So we're live on my YouTube and my Facebook as well for whatever questions you got, brother. So what can I do for you?
Oh, well, I was kind of wanting to see, you've been through Taos, you've been here to my home, everything else. What would you say your first kind of view of the area is?
I love New Mexico. New Mexico, there's my two favorite states in the nation are West Virginia and New Mexico. New Mexico is just beautiful. I mean, your house area there, it's gorgeous, and I love New Mexico. So, for what it's worth, I love it. But, I personally don't have knowledge of your area. You've told me about the corruption that exists in Taos, and that's Taos County as well, right? City of Taos in Taos County. Okay, yeah. So just so that everybody knows, with regard to New Mexico, where we're at on New Mexico. So I've served the Attorney General on behalf of Mondragon, the Mondragon family. He was charged by way of information, not indictment, in violation of the Constitution of the United States of America. So we served the Attorney General as well as also the Supreme Court. Patrick was with me, and we did that. So we've served the highest executive officer and the highest judicial officer for the state of New Mexico. And we've already served, I personally have served, Jessica and I, we've served the city of Santa Fe, which is the capital of New Mexico. We did that service. The video's not out yet. We're working on that. And then Patrick here has gone out and he's served the county of Taos as well as also the city of Taos. So we've got a couple of local legislatures that have been served within New Mexico, which of course, again, that enjoins and brings in the legislative element into it the moment that we serve them. So yeah, go ahead.
Just for clarity, I have not served the county yet. That should be coming up here within the next couple weeks.
Okay.
I did serve the town of Taos though.
Okay.
And I intend on doing quite a few more areas here. It's just been really busy.
Understood.
At this point, I have accumulated quite a following of people that are dealing with the same injustice that I am.
Yeah.
Through the same exact hearing officer
Right.
and the same exact judge. Right now we have protests set up for September 8th. And I've gotten 3 calls in the last couple of days saying that they're seeing public officials going and ripping down our flyers. Well, small town politics works a little differently when everybody knows everybody,
Yeah. And I'll be honest with you, like it's been a little bit hit or miss in what we're doing with the services and stuff. I found that the smaller communities are a little bit more receptive to us, right? But I don't know if that's necessarily because they care about the Constitution or because they're more concerned of the title of, civil rights advocate and litigator. And oh my God, we, better, act a little bit more appropriate or professional than we would otherwise. I don't know. But one thing that I am seeing, and that I can say, is that we are seeing a difference in the reception between what we would call a blue state and a red state. And it might surprise you a little bit to learn that we're actually being received much better from the blue states than we are the red states. We've been to probably 18 or 20 states now that we provide the service to the legislature. And I'm gonna tell you, we've gotten back 4 positive responses from the city councils or county commissioners, and all 4 of them were from what we would call blue state. New Jersey and Connecticut, Pennsylvania. These are states that they came out and asking, what do we do to address this situation? And so we are seeing, a little bit better reception to the things that we're saying coming from them. And there's reasons why I think that is. And it really boils down to, and once again, you guys, this isn't about politics. It has nothing to do with politics. There's no right or left, in my opinion. This is about America, American laws, the needs of the people. But what we got to remember is that the needs of the people are in conflict with the business, right? This corporation of America, right? And so when you look at the motivations of each side, the blue side are typically, more social programs and, let's pump money into that. And of course, we know from those what happened to that money. And it didn't go to actual programs that were going to help the people. It was actually, wasted. And that's not empathy, that's apathy. We need to be honest about that. But that's typically what you would see within the blue states is a lesser imprisonment rate, because the conservatives, they're about the business, right? We're gonna make this business a business. We're gonna make it more streamlined, and the business of government, they make their money off of the people and the expense of the people. So when it comes to enslavement of the people, you're going to see a higher concentration of imprisonment within the red states than you would within a blue state, which is true. Oklahoma, Texas, Alabama, Florida, those are red states that have got the highest concentration per capita of imprisonment rates. So, again, this isn't about, one party or another, but I wanted you guys to know that we are seeing much better reception, much friendlier reception from the traditionally blue state, the states, than we are the red states. But I was just in the middle of a video and putting out there, and and we just did on Thursday, we did the service to the city of Lexington, Kentucky, right? And this is the first time that I actually brought up this particular part of the narrative. And I said, you know what? I said, this is a tough decision. And I'm speaking to the city council and the county commissioners. They're in Lexington, Kentucky, they're all one. So it's the city of Lexington, of the county agents, or whatever it is. There's like 15 or 20 of these people here, a ton of them. And so I'm like, listen, Supreme Court of the United States came out in 1884 with a ruling that said, states, you don't got to do indictment by a grand jury. And what happened there was that the judge made a ruling from the Supreme Court of the United States, amended the Constitution in other than lawful manner. That's simple. Anybody with basic 8th grade civics would understand that that's what happened. And now the Constitution of the United States is not the foundation. Now the foundation is the judge-made ruling, right? Well, a judge-made ruling, even the Supreme Court of the United States has no constitutional authority to amend the Constitution of the United States, because that must be done by an authentic act of the people in courts with the special amended procedure of Article 5. This is not simple or not complicated stuff here. But I point out the fact that, listen, This is a tough decision, City of Lexington. I get that. It's a tough decision. Because right now, after being provided with this notice, letting you know that you are paying people to commit crimes and breach their constitutional obligations, you unfortunately are going to have to make a choice. Either one, you're going to continue to follow case law, right? Or two, you're going to choose to follow the Constitution of the United States. But that's the choice you're going to have to make, right? And then I ended it by pointing out that the United States Circuit Court defines an abuse of discretion. Abuse of discretion. And an abuse of discretion is any erroneous view of the law is an automatic abuse of discretion. So if you have an erroneous view of the law, that would be, according to the United States Circuit Court, an automatic abuse of discretion. And an erroneous view of the law is that in your legal contemplation, the lowest form of law, being a judge-made ruling, is superior to the Constitution of the United States, the supreme law of the land. That would be an obvious erroneous view of the law. Therefore, if you continue to pay these people to do their work, being aware that you're, paying for these crimes to be committed, what are you going to do then? Because you're not going to be able to claim negligence. And remember, ignorance of the law is no justification for having broken it. And when it comes to an abuse of discretion, according to Blackstone, there are 3 crimes that are automatic. One is perjury, because you made promise that you do something, you didn't do it, therefore you can't be trusted by the public to do it. You've already implicitly invited punishment should you fail to fulfill your obligations. So if you promise to do what the Constitution says and you breach it, or you pay for someone to breach it, doesn't matter. You've already implicitly invited punishment in the form of perjury for failing to fulfill that promise. The second crime is extortion, because you are compelling a result through illegal means. You are abusing the discretionary authority with which you're invested in law in order to bring about your desired result. Therefore, you are compelling a result through illegal means. You can never bring about a result through a breaking of the law, a breaching of the law. You can't do that, right? So I pointed this out to the city council, and this is really how I'm going to continue to do these services moving forward, is that they need to understand this is a tough decision. You guys are going to have to decide, are you going to continue to follow a judge-made ruling that's not law, that has, from a branch of government that has no constituted authority to be able to amend the Constitution of the United States, or are you going to follow the object of which your fidelity is bound in the Constitution of the United States of America? That's a decision they're going to have to make. And it's a tough decision, I get it, but it's a decision that I think is going to be fairly easy for them, especially when you point out that any erroneous view of the law is an automatic abuse of discretion.
So let me ask you, now that you're on the point of abuse of discretion, what are your thoughts on the fact that I know of 3 different cases? I'm not going to go into details on people's cases, but I know of 3 different cases right now that the district judge and the hearing officer have literally put out warrants on one for not paying, and then they call it bail. But then the bail, as they call it bail, I should say, then it goes to the party that they say for, one of them was like for child support. On a second one, they held the guy until his mother paid it. And it was like $12,000, and we're gonna hold you in jail until that's paid. I also know one right now that is being threatened that if it is not paid within a certain amount of time, they will issue a warrant. So what is your thoughts on basically, debtor's prison, I guess they call it?
Well, where do I even begin with that shit? All right, so first off, debtor's prison is a very interesting term because that's long since been ruled by the Supreme Court that you can't imprison someone for debt, right? You can't punish the poor for being poor. And yet that's what we do every single day, because here in America, if you choose to violate the law, you incur a debt that is owed to society, right? It's a debt that you're paying. In fact, the prosecutor would be like, oh, he owes a debt to society. He needs to go to prison for the debt that he owes. Are not these people in prison for no reason other than the fact that they owe a debt that the government says that you owe to people? So debtor's prison is not bad. You can't punish someone for being poor. And the bail system is a great example of this punishment. Because if you are arrested and then you don't have the money to pay your bail, did you know that you have an 80% likelihood of going to prison? Right? 80% likelihood. Innocent or otherwise, it doesn't matter, because you're going to be threatened, intimidated, and you're going to be held there until you're finally willing to admit that you are a criminal, and they'll send you off to prison for a year and a day, right? So if you can't pay bail, you have an 80% likelihood of going to prison. But if you can pay bail, you have an 80% likelihood of not going to prison. So all these people that are poor, that are being arrested and being sent to prison, based upon a plea bargain or whatever, they're going for no reason other than the fact that they are poor and they can't afford to pay, their bail. The bail system is absolutely punishing the poor for no reason other than being poor. But one of the things that I'm doing, so robbery and extortion are extremely close together in the criminal spectrum, extremely close together, right? Robbery is to formulate a contract through illegal means with the threat of immediate bodily harm. Okay, that's the definition. To formulate a contract through illegal means with the threat of immediate bodily harm. That's robbery. Now, extortion is to formulate a contract through illegal means with the threat of future harm. So the difference between robbery and extortion is one is immediate harm, the other is future harm. Okay? So let me give you an example, right? I have the power to bear arms. If I go out and buy a gun and I point it at you and I say, give me your money or I'm going to shoot you, what we're doing is we're formulating a contract for your money. But the way in which we formulate that contract is through illegal means, right? The threat of immediate bodily harm. That's the crime of robbery, right? You cannot formulate a contract. You are not giving your money because you want me to have your money. You're giving me your money because of the threat of immediate bodily harm that I've inflicted upon you. Therefore, the crime of robbery has in fact occurred, right? No denying that. Now, likewise, if I'm a prosecutor, right, public official, and I say, you better pay this money or I'm going to send you to jail for 12 years, right? Or whatever it might be. It's the threat of future harm. So what they're trying to do is they're trying to formulate a contract with you, a contract for your, for your time to go to prison. They're trying to formulate a contract with you, but the way in which they formulate that contract is through the use of threat of future harm. That's extortion. That's exactly what that is. It's extortion. You can never formulate a contract through the use of threats, intimidation, coercion, or duress without making that contract formed illegal. Because in contract law, a contract is illegal if the way in which the contract is formed is illegal, then that contract formed becomes illegal. So if you use duress, intimidation, coercion in order to formulate a contract, that contract formed is absolutely illegal, because duress is a justifiable defense for a crime of breach of contract or a tort. You can't hold someone accountable for the terms of a contract that you formulated through the use of threats, intimidation, coercion, or duress. Now, let's go ahead and take that a step further. Because if you were to look up the Title 18 for extortion, right, the law of extortion, federal statute, if you're to go to it and then you were to scroll down to item number 4, what it says is, I wish I had it in front of me and I'd tell you exactly, but I'm paraphrasing here. What it says is that these acts would constitute what would be considered threat under this statute, right? There's a little subnote at the end of extortion, and it says specifically that the following acts would constitute the threat under this statute. And what they say specifically is any threat of criminal sanctions would be considered a threat under this particular statute. So if they're threatening jail time, right, or criminal sanctions as a result of your failure to enter into their contract with them, that is absolutely written right in the law. Any threat of criminal sanctions would be considered threat under this statute. So, even written right into the laws of extortion, it specifically states that. So if they're coming to you and saying, well, we're going to send you to jail, we're going to give you these criminal sanctions unless you enter this contract with us, well, go ahead and go open up the laws of extortion and go down to the bottom of it. And it says right there that if you are threatened by criminal sanctions, that constitutes a threat under the law of extortion. It's written right in it. Now, the other thing is that in my part of what we're doing here is I'm attacking plea bargains. I've been attacking plea bargains the whole time. We're going to get plea bargains gone because they're an abuse of power. But what we've done is we've created what's called the formula of intimidation, right? All intimidation follows the same formula. And once I tell you the formula, then it'll make sense and you'll never be able to forget it. It'll always be stuck with you. But all intimidation follows this formula. And it goes like this. If you don't do X, I will do to you Y, whereby X is my envisioned outcome and Y as a result my powers can cause. Okay, let me say that one more time. If you don't do X, I will do to you Y, whereby X is my envisioned outcome and Y as a result my powers can cause. So again, let's go back to the robber scenario. I have the power to bear arms. If I point the gun at you and I employ the formula of intimidation, it goes like this. If you don't give me your money, I will shoot you, right? My envisioned outcome is I want your money. Result my powers can cause is I will shoot you. Therefore, you enter into the contract as a result of the threat or intimidation that I've inflicted upon you. The formula is in place. Now, if I'm a prosecutor, I have the power to give you charges. I have the power to send you to prison. If I abuse my power in the same way, employing the formula of intimidation, it goes like this. If you don't pay $12,000, I will send you to prison for 6 months. Right? My envisioned outcome is I want you to pay $12,000. Result my powers can cause is I will send you to jail for 6 months. It's the exact same scenario. It's the exact same formula being used by both sides. You can never use a threat of an abuse of your power in order to get someone to contract with you. You can't do it. Can't do it.
So let me cut you off for a second just to clarify here what's going on. They're calling it bail when they're telling, these people that they owe so much money in bail, but they're not taking it as bail. They're using it as a means of protection for the opposing party that they owe. So they're saying, their bail will be set at the amount owed for the other person, and then they're just turning it over to the other person.
Okay. So your money, let's say it's child support. Your child support money is a civil matter. It's not a criminal, it's a civil matter. Civil, right? So when you use a threat of a criminal sanction in order to force a person to contract with you civilly, it is not a bail. It is a threat of harm future in order to extort the money from you, in order to force you into a contract with them. It's not bail, right? Because they're threatening a criminal sanction in order to get you to comply with the civil action. Those two things are completely different. They have nothing to do with one. You can't punish someone criminally for refusing to contract with you civilly.
Okay, and then let me ask you on the deprivation of rights, which is basically your entire fight here, how does that tie into family court?
Okay, so I talked about this. I talked about this a lot earlier today in the live. So a prisoner is in a guardianship. It's as simple as that. He's in a guardianship. He's in a custodial relationship with the state. State is taking custody of him, and he is now in a custodial relationship with the state. Meaning the state is his guardian, right? You're in state's guardianship. And they put you into prison, right, so they can take care of you because you are incapable of taking care of yourself. That's essentially what prison is, right? Now remember, there's a child guardianship, there's an adult guardianship, there's an elderly guardian, but they're all guardianships. If you have a CPS case, for instance, and the state takes that child, they take that child into state custody, right? It's a custodial relationship. The state has custody of that child because you are not fit to take care of that child. Therefore, the state is doing it, right, and taking responsibility. Now, the same thing in a probate court, which would be elderly, guardianships, so on. So if the, I have a moth here. So if the state says, well, this elderly mother is not able to take care of herself. Therefore, the state comes in a custodial relationship through the probate and takes custody of that person because they're unable to have custody of themselves. All three of these are guardianships. All three of them. Prison, probate, family, they're all guardianships. Okay? Now, the reason why this absence of the indictment by a grand jury affects the family court matter is this. Family court and probate court are relatively new animals. We don't have hundreds of years worth of data to be able to know, the issues. We do, however, in a criminal court, because we can go back to Magna Carta there, right? We can see, okay, and Blackstone's been writing extensively on what happens when there's a breach of due process, right? A failure to follow due process. We can see that in the criminal court, right? The criminal court has a history that we can look at. Blackstone's written about it, and so on, so on, so on, so on. Anyway. All right, so what we're doing is we're looking at the behavior of the judges, because the old saying that how incredibly alike are all the tyrants, but how gloriously different are each of the saints. Tyrants are all the same. They all act the same because they're all being taught to do it the same way. So if the Supreme Court of the United States is the leader, right, and they teach all of their followers to follow their lead, right, then all of the judges are all being trained to act in the same way. Doesn't matter if it's criminal, family court, probate court, all the judges are being trained to act the same way. And here's how they all interact. Is that when you're charged by information, right, absence of the indictment by a grand jury, you're charged by way of information. What happens is that a police officer receives information, right, from someone that you committed a crime. And then that police takes that information, reduces it to writing in the form of an affidavit, and gives it to a judge and says, Judge, I'd like you to have this person arrested for the information that we got on him, right? That judge then is presuming that you are guilty based upon the accusation of having committed a crime. It's never been validated. You've never been found guilty of anything. Hell, the police has never even came and talked to you about what the story is. They just presume that you're guilty based upon the mere fact of being accused of committing a crime. So now you're arrested. That judge issues the warrant. You're arrested. You're brought into jail. You're deprived of your liberty. You're deprived of your property, your ability to use your property, make money, take care of your family, all these things that are protected by the Constitution. You're being denied because someone accused you of having committed a crime. And that someone is an agent of the state. Prosecutor, law enforcement, sheriff, someone within the state is accusing you of having violated the law. So what happens now is this sets up what is called an irrebuttable presumption of guilt. Irrebuttable presumption of guilt. It's an irrebuttable presumption of guilt because when it comes to an affidavit, right, an unrebutted accusation is truth at common law. We all know that. So if you don't have the opportunity to rebut the accusations, that accusation then becomes truth. Right? So absent the grand jury, right, you are presumed guilty, right, and the court presumes that you're guilty based upon the mere fact of being accused of crime. I have never had the opportunity to rebut those accusations, and as a result, those accusations now stand as truth. And so in the case of an irrebuttable presumption of guilt, it is the presumption that you're guilty based upon the mere fact of being charged with a crime. So now the judge presumes that you're guilty, orders your arrest, deprives you of your liberty, you're not taken to jail, and you are treated as though you're guilty. And now the defendant has to go out and collect evidence in order to prove that they're innocent, right? This is a shift in the burden of proof. Normally, the state and the prosecutor has to prove that you're guilty beyond a reasonable doubt. That's the way that it's supposed to work. You're innocent until proven guilty. The prosecutor and the state must prove that you're guilty beyond a reasonable doubt, and that's the way the system is supposed to work. But not with an irrebuttable presumption of guilt. In an irrebuttable presumption of guilt, the burden of proof shifts from the prosecutor onto the defendant. Now the defendant has to prove that they're innocent because they're already presumed to be guilty based upon the accusation, right? And according to Blackstone, this is a breakdown of due process that occurs when the system focuses on speed and efficiency as opposed to the established procedures and processes, written in Blackstone. All right, so that's the scenario of the behavior of the judges in a criminal court. You are presumed guilty because someone said that you committed a crime. Now you have to prove that you're innocent, right? That's what happens. If that's the behavior of the judiciary in the criminal court, then it's the exact same behavior of the judiciary in the family court. Because in family court, someone, CPS, a GAL, whoever, accuses you of being unfit to be a parent, right? And now you are deprived of your protections, your constitutional protections, based upon the mere accusation of being unfit. And now you have to go out and collect evidence in order to prove that you're fit to be a parent. This is a shift in the burden of proof. The state has to presume that you're fit to be a parent, right? In the same way that the state must presume that you're innocent until proven guilty. It's the burden of proof for the state to prove that you're unfit. But that's not what happens because the judges are all being trained in the same way that they're being trained in the criminal matter. But the problem is that we don't have any empirical data from Blackstone to show this breakdown due process in the family court because it's relatively new. We do in the criminal court. I can show the breakdown due process in the criminal matter and where the judiciary and judges are presuming that you're guilty based upon the mere fact of being accused of committing crime, but I can't within a family court. So I have to use the data and the evidence and the writings of Blackstone within the criminal court to show that's the same behavior of the family court. You guys are not presumed that you're fit to be a parent when an agent of government accuses you of being unfit. That judge automatically says, oh, well, you're obviously not fit because this government agent right here said that you weren't fit. Therefore, we're going to remove your right and we're going to presume that you're guilty until you can prove to us that you're not. That is a shift in the burden of proof. It's the same behavior. Same thing with a probate court, right? In a probate court, if someone, a GAL, a psychologist, whoever that might be, says, oh, this person can't take care of themselves, they're unfit to be a person, right? Then they take them into guardianship. And they say, okay, well, you're going to remain in this guardianship until you can prove that you're fit to be, take care of yourself. It's the same exact procedural situation, the same exact behavior between the judges, regardless of which type of court they're in. But I have to go with one that has the data and the evidence and the writings of Blackstone to be able to point across to these other courts and show it's a breakdown due process because of the behavior of the judiciary in all three.
So let's go back to discretion real quick. Do you think that these judges really believe when they say that they have basically unlimited discretion? Do you think they believe themselves?
Yeah, they do. They believe that. But once again, if the Supreme Court of the United States has told them that they do, right? Told them, oh, you got immunity. You guys are sovereign and immune. Right? You don't have to follow the Constitution such as they did in 1833 in Barron versus Baltimore, or again in slaughterhouse cases or Cruikshank cases, or the civil rights cases of 1800s, or the Hurtado versus California, or Hans versus Louisiana, or any one of these other bullshit Supreme Court decisions that have been put into place. If the highest court in the land says, yeah, you guys, you're free, you're immune, you can do whatever you want, then they're being taught that they can do whatever they want, right? They're being told that they can do that, yeah? And so that's why the fight really isn't against the local judges. Yeah, they're absolutely breaking the law. And negligence of the law is not justification for having broken it, right? There's no way that the local judges can get out of it, but the fight's not with them. The fight is with the Supreme Court of the United States. They have to decide that they're going to act constitutionally, obey the Constitution, and when they choose to do it, then they have to teach their agents to also obey it. The Supreme Court of the United States doesn't believe that they're doing anything wrong. They're arrogant, narcissistic pricks that think that they're perfect, right? And that they don't do anything wrong, when in all reality, they're the source of all criminality that exists in the world, because at the end of the day, there is no guilt where there is unlawfulness, right? So if the government is acting unlawfully because the Supreme Court of the United States directed them that they don't have to obey the one law that binds our nation together, the Constitution of the United States, such as they did, then that means that the government is not acting lawfully, which means that there cannot be guilt. So the truth is that the real criminals are not the people. The real criminals is the Supreme Court of the United States. They're the real criminals because, but for their unlawfulness, we could have guilt. But because they're breaking the law, you can't find anybody guilty because where there's unlawfulness, there cannot be guilt. As long as government is acting unlawfully, you cannot have guilt. That's written in 2 Thessalonians. I mean, that's written in Scripture. You know, where there's unlawfulness, there cannot be guilt. So, you know, one of the things is like, I'm not fighting for anyone's innocence. I don't know if these people are innocent or not. I have no clue. That's not my job. That was the state's job to determine guilt, and they didn't do it because guilt is a process, and you must follow that process. And if you don't, there cannot be guilt. So I'm not fighting for anyone's innocence. I'm fighting for their guilt, and I can ethically and morally do that because they aren't guilty. Because guilt is the process, and you didn't follow the process, states. You haven't done it. You broke the law, and in your breaking the law, you cannot deem anyone else have broken the law.
Okay. Hey, do you by chance know how to flip the screen to just a dual screen?
I
I don't
don't.
know how to do any of this live stuff, so.
Maybe someone down there. I don't know. I don't. I know you can do it. Yeah, actually, I've seen people that do it. There is a setting button up. Yeah.
Well, okay, I just figured I'd ask you. So, like what I'm dealing with here, again, would you, the way we were talking about it, would you say that they're basically running on extortion then, as for the way that they're collecting funds by threat?
100%. Yeah. It's not basically, it is. It's extortion. Extortion is compelling a result through illegal means, right? Compelling a result by breaking the law, right? So if their result is that they want you to pay them $12,000, right? Then the way that they're getting you to pay $12,000 is by an abuse of their power, by leveraging a different court, by bringing criminal sanctions against you in order to settle a civil matter. Yeah, that's abusing your power. That's compelling a result through illegal means. You can never force someone into a contract without committing robbery, extortion. And that's what they're trying to do with you, right? They're threatening criminal sanctions and telling you that if you don't pay the if you don't pay us, then we're going to send you to prison or to jail, or we're going to hold you there until you do pay. You can't do that. You cannot punish someone because they can't pay you, right? You can't punish someone because they don't want to contract with you or your corporation.
So then it's also a complete violation of the separation of powers.
Yeah. So this goes back to the Constitution. The child support issue, for instance, is a separation of powers issue, because so according to the Constitution, Article 1, the only branch of government that can create a debt or a tax against the people, the only branch of government that can tax the people is the legislative branch. All tax must originate from the legislative branch, because we here in America, we didn't want the king or his agents to be able to tax the people. We wanted the people to be able to decide whether or not we owe tax. Hell, that's what we learned from taxation without representation in the stamp tax. The fact that we weren't represented by Parliament and we were being taxed without our ability to say, no, we don't want to be taxed. So that's why in the Constitution, we said that all tax must originate from the legislative branch. All tax must come from, only the legislative branch can tax the people, okay? Now, why do I bring that up? Because in the courtroom, all three branches are represented, all three. The judge is the judiciary, right? The prosecutor is the executive. The jury is the legislative, right? So in a courtroom, it is the jury that represents the legislature, right? So if you're going to have a debt or a tax brought against you, that tax must originate from the legislative branch, which is why Amendment 6 says that the trial by jury shall not be infringed. Why? Because if you owe a debt to someone, that debt must originate from the legislative branch, the grand jury. It's the grand jury that decides that there is a bill against you, a bill of indictment. But the 7th Amendment says that in all matters of equity and law exceeding $20, that there must be a jury trial. Why? Because the jury is the legislative branch. So absent a jury to determine whether or not you owe a debt or a tax, that means that that debt or tax is coming from a branch government that does not have the authority, the constitutional authority to be able to create the tax. So when child support originates from CPS, right? And CPS is an agent of the executive branch, right? And then that judge says, yeah, I'm going to say that you got to pay $800 a month, Mr. Medina. You're going to have to pay that $800 a month. Well, that judge has no authority to create a tax against you because according to the Constitution, it must originate from the legislative branch. That's why the right to a jury trial in matters exceeding $20 was to be preserved, right? And maintained. Because otherwise, it is the judicial branch or the executive branch that's creating a tax against you, which would be a separation of powers issue. The legislative branch is the only branch of government that can create a tax against the people. Therefore, child support, tax against the people must originate from a jury. Right? Another example would be your speeding tickets. You're traveling down the road, right? You get pulled over, and they issue you a citation, $100 citation. Well, now you go into the courtroom, right? And that citation, that debt, that tax that you're paying did not originate from the legislative branch because that officer works for the executive branch. That's why all matters exceeding $20 must be trial by jury, because the officer has no authority to be able to tax you. The judge has no authority to be able to tax you. That tax must come from legislative branch, which is the jury trial when it comes to a courtroom. So, it's a separation of powers issue that has to be addressed because according to our laws, what we created, what we delegated, what we established, what's written in the Constitution is that the executive branch and the judicial branch have no authority to tax or create a debt against the people.
Well, when you go into family court, the judge, the hearing officer, whoever it may be, they are judge, jury, and executioner all in one.
Of course. Right. But and that goes back to this absence of the indictment by a grand jury, because the purpose of the grand jury is to protect the accused from hasty or malicious charges by a state. Right. The purpose of the grand jury is to protect the accused from the accuser, the state. But today we have the state that creates and decides what is or is not a crime. We have the state that investigates what is or is not a crime. We have the state that accuses you of having committed a crime. We have the state that judges you on whether or not you're guilty of committing that crime. And then we have the state that profits off of your involuntary servitude in a for-profit business for the direct benefit of the state once you're deemed a criminal, right? Where is the neutral, unbiased decision maker in this process? When all elements of the state are against you and there's no neutral, unbiased arbiter to make sure that the state is not exceeding the power authority statutorily conferred upon it, right? There is no protection for the accused. Now the state can bring whatever arbitrary, capricious allegations they want against you, whether you're innocent or not, and they're going to use their entire array of power in order to force you into doing whatever they want you to do. And if you buck up against them, they're going to come down even harder on you because there's nothing to protect you. There's no jury, there's no people there, right? To determine, one, is there even a crime committed? And two, whether or not you're guilty of beyond a reasonable doubt of having to committed that crime. The state doesn't want the jury in the process because the state would then have to actually start doing its job, right? Have to start investigating, collecting evidence, actually having to follow the law, right? But absent the third branch of government, the legislative branch in that courtroom, these courts are able to do whatever they want. It's a consolidation of powers into a single set of hands, which according to Thomas Jefferson is the very definition of tyranny.
And then once it's in that single person's hands, you get charged contempt. Well, that contempt is against the judge, the judge is, against his order. So then the same person that they're accusing you of a crime against is the one that also gets to, be your executioner, basically.
Well, there's the irony that we have to deal with, isn't it? Right? So a contempt of court is a failure to follow a court's order, right? What is the court? The court can't give an order. Only the court's agent can give an order. So if the court's agent gave the order and you failed to follow the court's order, then who's the offended party? The judge. He's the offended party. You didn't obey him. You didn't bow down and kiss his ass, and because he gave you an order. But we, the people, don't have to follow orders, right? We are the sovereign. We are the masters, not that judge. That judge is the lowest on the totem pole, right? And yet it's the judge that you have offended, and now the judge is acting as both judge and jury in this problem. That judge, there's two main issues here. One is that when that judge orders your arrest, right? He says, bailiff, arrest this lock him up for contempt of court. I'm going to give you 90 days, bam, bam, bam. Well, you know what, judge? You don't have the authority to perform an arrest or order an arrest, because that must be done by the executive branch. And when the executive branch isn't the one issuing the order, it's you, judge, then guess what? You're now practicing from the bench, because you don't have the authority to order an arrest, because your role is to determine, and arbitrate the issue. So when a judge does say, oh, I'm going to hold you in contempt, bailiff, arrest this guy, well, judge, you just practiced from the bench. You don't have the authority to order my arrest, because that has to be done by a different branch of government, not your branch of government. And then if you are practicing from the bench, well, one of two things has to happen. Either one, you're disbarred, or two, so when you look at the issue of contempt of court, how is that judge going to determine that you're guilty when he himself is the offended party? Contempt of court is bullshit. Total bullshit. And contempt of court with the criminal sanctions, the criminal penalty, well, judge, you don't get to order an arrest. And if you do, well, then you're going to have to, tell us why you're practicing from the bench, because that's not the role of the judge. The judiciary does not get to order arrests. That only comes from the executive branch. Right? That can only come from them. So absent an executive branch agent, a judge is now pretending to be an executive officer and not a judicial officer. But then in the same breath, they're also acting as the judicial officer by saying you're going to go to prison or jail for 6 months. Pretty tough situation if they're in there, as far as I'm concerned. But that's the issue of this overstepping separation of powers and not understanding their role within our system of government. And if you don't know the role within our system of government that you're filling, then maybe you shouldn't be a part of our government, because that's a pretty dangerous thing to do. Because if you're overstepping the separation of powers, that's actually, it's actually kind of treasonous. I mean, I'm pretty certain that Cohen versus Virginia said that, but we won't go there.
Well, then when you call them out on this, or you try to bring anything about them, especially about practicing law from the bench, then it turn it into back to discretion.
But it's not discretion when the separation of powers exists to limit the powers of government. The judiciary has a very specific limits of powers, codified within Article 3. The executive branch has a very specific limited powers, codified in Article 2. Legislative branch has a very specific limited powers, codified in Article 1. So it's not discretionary to abridge and overstep the separation of powers. That's a complete breach of constitutional obligation. Constitution creates limits of government. Those limits are intentionally created in order to preserve the individual liberties of the people. So it's not discretionary to say, oh, well, yeah, this is not really my job within the Constitution, but I'm going to do it anyway, because that's tyranny, according to Thomas Jefferson. Very definition of tyranny. So no, I mean, it's not discretionary to exceed the power or authority statutorily conferred upon you by the Constitution. Remember, I opened up by saying, what is an abuse of discretion? An abuse of discretion would be an erroneous view of the law, right? So if the Constitution is the law, right, that's the highest form of law, and you say, yeah, you know, we don't have to follow that because this state statute says we can do this, that would be an erroneous view of the law. And if you're breaking the law by transgressing the law in any way, that's a crime. It's abuse of discretion. So yeah, but that's the one thing that they claim that they have, because that's the one thing that nobody really argues with them about. Oh, well, I guess he's got discretion. The fuck you do? No, discretion can never be used with regard to one's obligations. Obligations, constitutional obligations, must be performed because otherwise you're using your discretion abusively to break the law. You can't use discretion to break the law, right? Because that would be an abuse of discretion. Doesn't matter if the law creates a separation of powers horizontally, or the law creates a limit or an obligation. If you break the law, you exceed the powers that the law limits, you're not justified in your action. There's no discretion that can be applied with regard to one's obligations.
So upon like committing any of these violations that you spoke of, would you think that would cause them to lose immunity?
Yeah, of course. I mean, anytime you're acting outside of the law, you're committing a crime. There is no immunity from criminal conduct. You know, that's the problem that we deal with here. Like, guys, open up Black's Law Dictionary. I mean, open it. Hell, go on your phone right now and just do a search, Black's Law Dictionary, and look up sovereign immunity. Someone look up sovereign immunity and tell me what the definition is. It says immunity from civil liability for the work conducted or for your actions conducted within the course of your business, right? It is immunity from civil liability. Civil liability. Guys, there's two different types of liability. There is civil liability, there's criminal liability. Those are two different liabilities. You're immune from civil liability, but you're sure the hell not immune from criminal liability, which means that you can be held criminally liable for the crimes that you commit, but we can't sue you for the work that you do because we have to sue your master, the state, right? You're immune from civil liability, but you're not immune from criminal liability. And even the Supreme Court in 1978, case called Imbler versus Pacman, IMBLER versus Pacman, PACHTMAN. Imbler versus Pacman says, even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivations of constitutional rights. Even the Supreme Court in 1978 defined that there's a difference between criminal liability and civil liability. Yeah, judges are civilly liable. They've been civilly liable or civilly immune for years, cloaked in absolute civil immunity for centuries, but they can still be held criminally liable for willful deprivations of constitutional rights because there is no lawful authority for a public official to abridge a constitutional obligation. You can't use immunity with regard to the law. Otherwise, to what purpose is the law? To what reason did we create a constitution if those that are bound to be restrained by the Constitution can break it by their discretion? You know?
So I'm bringing up a few things about constitutional rights, and the judge here literally told me that, or he actually put in the paperwork, that they go by state statute, by state constitution, not by U.S. Constitution. But, you know, where do they get off thinking that that's even possible?
Well, that's going to be a very dangerous situation for them. Because the only reason why the state exists is because of the Constitution. Right? I mean, you got to look at the hierarchy of law. We, the people of the United States of America, we created the Constitution. Right? We created that. And the Constitution then creates jurisdiction, which is the authority for the court to speak the law or render a decision, lawful decision. So the Constitution creates jurisdiction. Jurisdiction then creates the court, and the court then creates the court's agents. The court agent, the judge, is the lowest on the totem pole. The people are the highest. We, in our sovereignty, created the Constitution, which is what created the authority for the court to exist, which created the court, and then the court created the agent. So the agent can't say, that which created me doesn't matter. I don't have to follow it, because that which is created cannot be above the creator. I mean, even Chief Justice Marshall stated in Marbury versus Madison that which is created, the peasant can't be above the king. That's in irony too complete to even be contested, I believe, is what the ruling stated. But nonetheless, the lowest person, the peasant, the nobody, the nothing, that which is created is the judge, and the judge was created by the law. So that which is created cannot be above the creator, because absent the law, that judge doesn't exist. Because absent the law, the court can't be a court, because jurisdiction is not granted to it. No state can say that the Constitution doesn't apply to them without warring against the Constitution. Very, very simple.
Let me clarify, just so that I'm not spreading misinformation here. The words that they put in there is New Mexico state courts operate under the New Mexico Constitution and the New Mexico statutes, not under Title 28 of the U.S. Code, is what they put.
Okay, so the highest form of law in the state of New Mexico would be the New Mexico Constitution. But the New Mexico Constitution has placed itself in subjection to the United States Constitution, because the United States Constitution is the overarching requirements that govern all the states. That's why this Constitution and the laws of the United States shall be the supreme law of the land. So the question that you would want to ask then is, well, Judge, are you saying that you're not part of the United States of America? Because the only thing that makes the United States of America exist is the Constitution. So if you're saying that you don't follow the Constitution, then you are saying that you are not a part of the United States of America. That would actually be an act of war against the United States of America, not just warring against the Constitution. Like, that would be a very dangerous position for that judge to be in. But if that's what he's saying, okay, that's fine. I'll just go ahead and, contact our, local military here and let them know that you are, refusing to, obey the United States of America after having swore allegiance to it through your oath, Judge. I mean, it's a pretty difficult position for them to be in. But, they say that every single day, all across the country. I mean, probably 100 times just in the last few months, we've heard judges say that, right? But this is a last ditch effort to try to hang on to something that is sinking miserably, that they are not going to be able to get out of. So, if that's the direction that they want to go, they want to claim that they are not subject to the laws of the United States. Well, they're putting that noose around their own neck. We're not doing it. They are. Because the people are morally justified in whatever action they take, because the law permits us to take traitors out to the nearest street corner. We know that. We know what the law says. And, that's not coming from me. That's not a threat. That's what the law states, and that's what the people are permitted to do. If you're going to decide that you're going to war against the Constitution of the United States after swearing by oath or affirmation that you will support it, that's just not a good position to be in, Judge. It's not a good position to be in, state, because, well, we'll just have to see it.
Now that I just read you there, that's in the actual court order. They're not even trying to hide it. They're just blatantly saying we're not going to.
Well, I mean, I would first probably send that to the FBI, but here's the thing. When you go to Treason, which is Title 28, I believe 2381, I believe it is. Anyway, it says that it must be a declaration made in open court, right? Or in the presence of two witnesses. I'm pretty certain that that's a declaration in open court, that they just said, we don't have to obey the Constitution of the United States. So I think that you have some pretty strong evidence there to be able to take to, take somewhere, because the Constitution specifically states that if there's a declaration in open court, commission in open court, that is the crime of treason, and that is a declaration in open court, because if they put that in a court order, that was an open court declaration. And if the declaration is, we're not going to follow the Constitution of the United States of America, I would say that judge is probably subject to be taken out to the nearest street corner at noon and disposed of. I mean, I'm not saying, I'm just saying that's what the law permits. So,
I got you. I'm just wondering all these stuff that I'm going to, I mean,
I would start with one. I would send that to the FBI, do a record on that first off, say, here's treason stated in open court, point to the Constitution, point back to the statute and say, you either address this or, we're going to be taking this up to the next level. That's actually a war, an act of war against the United States of America. That is a declaration of war. I mean, that's no different than the state of South Carolina saying, we're not going to follow the Constitution of the United States, we're seceding now, right? That's a statement made by an agent of the state, an officer of the state, judicial officer of the state, declaring, right, in a public, open court statement that we are in direct rebellion against the United States of America. We are now warring against the United States of America, and I would say that if that's true, then it might be time to bring the military in, for that. But it has to be a statement made in open court. And that statement right there, I would say, if that was made in a court order, then that was a statement made in open court.
All right, that's good information to have here, because it seems like anything that we do over here, they just shoot it down, and that's that. This next things that are actually going out are all going out to the Attorney General as well, due to some violations like that.
Well, so it won't go to the Attorney General, because the Attorney General is not, for the state Attorney General is not the right entity. You're not reporting the crime to the proper agency. The state is not involved in this anymore. Once the state declares a state of war against the United States of America, deprivation of rights under color of state law, then the state is no longer involved in it. You go to the federal side. And according to the law, the federal law enforcement, the FBI, is the agency that you would report to. You don't take anything else to the state. The state has already created a law that forecloses upon the petitioner's procedural situation, which is a bypass of your requirement to exhaust any more remedies with the state. There's nothing else you have to do with the state. You don't go to the state attorney general and ask, well, you got a law that's in violation of the Constitution. He already knows. He's a part of it. So even civil rights and elective franchises, the Title 28, 1343, which is the jurisdictional code that determines who arbitrates or who has original jurisdiction in a matter of a violation of civil rights, right? That's Title 28 USC subsection 1343. It says that the United States District Court shall have original jurisdiction of any civil action authorized by law to be commenced by any person. But what that particularly says is, it says that you don't have to go back and exhaust remedies with the state or argue with the state or spend any more time with the state, because there's a bypass of the exhaustion of state remedies, right? If the state has a law that's in place that forecloses upon the petitioner's procedural situation, you don't spend any more time within state courts. You don't have to get a decision from the Supreme Court to bring it in federal court. You don't got to spend another second with your state court. If they have a law that forecloses upon the petitioner's procedural situation, you're done. Go to federal court, right? 1343, civil rights and elective franchises.
And is that part of the exhaustion doctrine then?
There is nothing to exhaust. It's a bypass of the exhaustion mandate. Normally, you would have to exhaust remedies. Go get a decision from the highest court in your state before you bring it into federal court. Ordinarily, that would be true unless there's an exhaustion bypass, right? An exemption to the exhaustion, which is defined within Title 28, 1343. And it says that if the state has a law that forecloses upon the petitioner's procedural situation, there's nothing more to exhaust. You're done. Go to federal court. Elect civil rights, elected franchises. If the state has violated and deprived you of rights under color of law, there's nothing more to waste. There's nothing else you have to do with the state courts because they have a law in place that forecloses upon the petitioner's procedural situation. If you're being deprived of rights under color of law, you don't go back to the state to say, oh, state, you're depriving me of rights. You don't have to go to the highest court because they already have a law that's in place that forecloses upon your procedural situation. So according to Title 28, 1343, civil rights and elected franchises, then federal court has original jurisdiction of that matter.
Well, and I'm kind of at a loss now because I pretty much answered everything that I was wanting to go over with you.
Good, because I'm tired, and it's 9 o'clock, and it's hot here for some reason.
It's been crazy here too. It's one day we're with the heater, the next day with the air conditioner.
It's like I don't know, it's like 60 some degree, but in the house here it's kind of warm. But we got blessed with a nice Airbnb for this weekend, for the long weekend. So we're trying to get caught up on some stuff here, and so a big blessing. Actually, we got another blessing. We got donated one of those little teardrop trailers, an Airstream trailer that we can haul behind the band. So we're going and picking it up next week, and that'll be nice to not have no room within the van and have a place to go to sleep and stuff. We need to. So okay. Hey guys. So Jess just tossed me something here. So we did get blessed with this Airstream trailer. The problem is that we need a little bit of work on the van in order for it to work, because we got to get the shocks on the van are shot. We got to get them replaced. The brakes are shot, and the hitch is we also need to put a hitch on. And so if you guys want to help support that, if you guys would like to donate, we would very much welcome the donations. We need about $500 for those items. It's going to be done by our brother Jesse James in Michigan. Thank you so much, brother. The trailer is being donated from Dave Weigel. Thank you so much, Dave. It's going to be amazing to be able to not have to worry about hotel rooms every single night wherever we're going. And again, we're just going to be on the road, guys. This is what we're doing. We're committing to this. We're not going to stop until the court hears the case. And the only way the court's going to hear the case is by raising enough attention on this issue to where they can't ignore it anymore. So I want to also say that, you guys, if someone contacts you, if someone messages you and asks you for money, it's not coming from us. There are fake accounts for me, and there are fake accounts for Jessica. They are not us. We have never and will never message you asking you for money. Ever. Never. So if you want to donate to the cause and you want to help us out, you're welcome to do it. But it's through Cash App, Chime, Venmo, PayPal, and they're all exactly the same, right? This is the we shall be free term. Therefore, all of our source points are we shall be free. Donate to we shall be free, Cash App, Chime, Venmo, or PayPal. And if anybody says to donate to anything other than we shall be free, they're a scammer, right? And I'm telling you that we know right now that one of the scammers is the Pure Cure guy, right? Y'all remember Pure Cure? Pure Cure is one of the people that is scamming you. It says scam you out of thousands of dollars. And the authorities know about it, and it'll get addressed. I don't know if he's the only one, but I believe he probably is. But nonetheless, if you guys are out on his Telegram page, he's pretending to be me. He's stolen my picture. He's stolen my videos. He's lying to you guys, stealing your affidavits, and he's about to get himself burnt, all right? Because the authorities do know about it, and he has stolen thousands and thousands of dollars from you guys. But here's the thing. If you guys get scammed, don't blame me. I've been telling you guys over and over and over again, the source of the donation points. I've told you guys numerous times that that we will not contact you. If someone sent you a message and you donated to them and you got burnt, please don't come back and lash out at me and act like I'm somehow scamming you, right? I'm out here getting my work done every single day, trying to help all of you. And it really pisses me off when you come out talking shit about me and how I'm stealing from you when I'm sitting here with no money, right? I mean, I can barely even fill the car up with a tank of gas. So, if you guys get scammed, don't blame me, right? I'm sorry that that's happening to you, but we can't change the scumbags that exist in this world, and Pure Cure just so happens to be one of those scumbags. So please don't get yourself scammed.
Tell them how.
Just so we're aware also, they're not just, the scam accounts, they're not just asking for money. What they're doing is they're offering services.
Right.
They're offering affidavits, they're offering legal help, they're offering all this stuff. It's the same message every single time, so they're not just asking for money. So people need to be aware of that also.
Well, so that they introduce themselves by saying that hey, we're here to help. But then as soon as he messaged back, he says, well, yeah, but you need to send us money in order for us to have a FaceTime call or something. I mean, Jessica had a conversation with him one day, and that's one of the ways that we got some information from him. But nonetheless, so like one lady, he messaged and she got so excited. She's like, oh my God, you're gonna come out to my city and help me with my case and blah blah blah. And he said, yeah, but you need to give $2,500, for a fee, right? And she sent him $2,500. Guys, I have never received $2,500 ever. In fact, I don't have I've never had $2,500 in my account since we started doing it. I operate from $200 to $300, at any given time in that account, tops. So, and she donated that, and then she came back, to me. And the problem is that it's not even my name, guys. It's not even my name. My name is Tanawah, Tanawah, and this name is Tawanah. That's not my name. It's not my name. And so if someone contacts you offering my services, saying that they'll come and help you with a case, guys, I've been real clear, and I will be very clear once again. I don't work for anyone. I only work for everyone. I will not come out and fight anyone's individual case because I don't need to. What I'm doing is going to resolve everyone's case, and that's why I'm not going to go and do it. I have never once offered to come to anyone's place and help them with their case, ever. Never offered it. So please don't get me wrong. If I end up in your city, right, I'm happy to come and see you, but I'm not going to walk into a courtroom and argue a case on your behalf. That puts me into a very dangerous situation that I'm not going to put myself into. I don't need to put myself into that situation, right? I can deal with this, but the way I'm dealing with this is one case for all, right? If your arrest was unconstitutional, if the state exceeded the authority statutorily conferred upon them by the Constitution, then I can fight one battle against the Supreme Court of the United States, and in winning that battle, it will provide the relief that you need back out at the state level. I'm not going to fight all the millions of cases across the country. So I'm not going to come out to your city and help. And you're right, but we think that there's probably some government involved in that as well, along with Pure Cure. We think that it's also got some government involvement because, this has really had a significant impact on the credibility of me and, this effort and what we're doing. And they're causing a lot of damage to it, a lot of damage by stealing from people, and pretending to be me. And then these people come back and say, oh yeah, he's a scammer because I gave him whatever money and he never, apologized. It wasn't me, right? So these people are having a significant impact on the credibility of this effort. But it's not me, guys. I have never scammed you. I'm out here doing the work every single day. And so, when people come in and say that's me or something, you just get blocked. You're done. And it has nothing to do with anything other than the fact that I'm not going to deal with someone's negativity. If you were scammed and you didn't take the time to actually know who it was that you were donating to, or look at the name, or I'm sorry, I can't have you know, I can't offer any sympathy for that. I can't. I'm sorry. You know, I'm trying to get a job done, and I'm trying to do it with minimal, you know, funding to do it. And this asshole or assholes have stolen a lot of money, way more money than I get, and that's damaging the movement. You know, because now all these other people are now coming out and saying this is a scam. No, okay. So anyway.
All right, brother. Well, I'll put your Cash App and all that stuff out there. Try to round you up a little fun to cheer. I appreciate you coming on and talking to us for a little bit. And God bless. Keep it up, brother. You're doing good. You guys are killing it.
Appreciate it, guys. Appreciate it so much. Jessica appreciates it. Thank you, guys. Please continue to like, follow, share. Please repost whatever videos you can. That's going to get it back out in the queue. It's a very, very important thing, because every time you repost any one of my videos, it gets it back out in the queue, and that gets it in front of an additional audience. So that's what makes these videos and information pass the fastest. We're back out on Tuesday morning in a new state. We're 14 hours away from Kentucky, where we last served on Thursday, Lexington, Kentucky. And we should have a pretty bang up week this week. But we do have to make it back to pick up this Airstream. So we will be doing some repeat in some of the states that we've already been. But nonetheless, we are about to start another loop around the country. And Jessica and I, we were just talking about that. I would like to do a high north, which would include North Dakota and hopefully some of Wyoming, down to a low southern loop, which would be like San Diego, Tucson, Las Cruces, and so on along the border. That's kind of the direction I was wanting to go. Don't know, but nonetheless, we're about to do another Western loop. And again, we're just going to keep doing this until the court agrees to hear the case. This is a matter of raising awareness and informing enough people about these breaches of constitutional obligations by these states. And you know, so that's why, if you guys want to help serve, if you want to get involved, you can download the script to read and the notice to provide from justicewithoutlimits.org. So if you want to serve your local city council, you want to serve your local county commissioner, you want to help us to be able to spread this information quicker, we would welcome the help. All you got to do is go in and read a 2-page script, right, on the record during public comment, and then provide them with the 4-page notice that are both available on justice.limits.org. Okay, so we will welcome.
Training tomorrow at 4:30.
Training tomorrow at 4:30, and I'm also going to start doing. Every single Sunday at 4:30, we will be live. So you guys go ahead and get ready. We'll call it a show, whatever. Talk about justice every single week at 4:30. From now on, you will be able to rely upon seeing me on TikTok, YouTube, Facebook Live. I'm going to be on anyway, regardless. So we'll be doing a regular weekly show every single week at 4:30, but it's going to be in conjunction with the Zoom, right?
So if they want to interact.
Yeah, if you want to interact, you guys can get on the Zoom. Yeah.
So I just posted a link.
Facebook?
On Facebook, yeah, on the last video.
Okay.
So that they can go and sign up. They need to register on that form before 12.
Okay. So if you guys want to get on the Zoom, right, with Jessica tomorrow at 4:30 Eastern time, 4:30 Eastern time, then you can go to her Facebook page. That's Jessica Saxton, Saxton, Jessica Saxton on Facebook, and she'll have the Zoom information there. You can register, get on the Zoom, and she takes you through a little short training on what to do for these services, city council, county commissioners, and so on. But at the same time, we will also be starting the shows every single week. So, you guys can expect to get on there and I'll talk, bloviate for a couple hours every Sunday at 4:30. Okay. Love you, brother.
All right, brother. Appreciate it. Love you guys. You guys be safe out there, and God bless.
All right. Give your daughters a squeeze for us, man. Love them too.
Will do. They ask about you every single time.
All right, brother. Thank you.
All right. Have a good night.
God bless. Thank you. Yep. Bye. Ow. Thank you. I don't even know who we got. Thank you so much. God bless, guys.